sight. Get what we need.
And this is this week's Closet Classic.
Welcome to Speaking of the Law. I'm attorney Marvin Greenberg. This is one of a series of legal programs on topics that you, our audience, have many times chosen for us. We hope that these programs are both interesting, educational, and hopefully even entertaining. We're going to ask that our audience writes to us and choose legal topics at a later time. Each time we will choose a guest who will discuss with us that particular topic. Tonight's topic is entitled Resolving Disputes by Mediation. We're very fortunate to have with us today Chuck Duran. Mr. Duran is the founder and executive director of Mediation Works Incorporated. Chuck is both a mediator who has successfully mediated hundreds of cases in Massachusetts in areas of both civil, criminal, divorce. He's also a mediator and mediation and negotiation trainer, and he's also a consultant in mediation in a variety of organizations. We want to thank you for being with us today, Chuck.
Thanks for having me.
Chuck, as an attorney, I view myself basically as a communicator, hopefully, in behalf of my clients. And many times I'm faced with issues that when it's less desirable in my client's interest to go before a judge as a fact finder or a jury. And many times mediation would be much more preferable. I'm going to ask you to describe to us as far as the alternative forms of dispute resolution, mediation and arbitration, and how do they differ?
Sure. Well, I think to describe mediation in simple terms is assisted negotiation, is where perhaps one of your clients who maybe has an interest in trying to resolve the dispute without going to court and may want to sit down with the party who they are in dispute with, the mediator would assist them in their discussion and hopefully work out some resolution that meets both of their interests. And mediation is just one type of dispute resolution in the what's known as the ADR or alternative dispute resolution spectrum, which includes mediation and arbitration, where a neutral third party would make a decision about the outcome of the dispute for the parties. And the way that differs from mediation in that the mediator does not make a decision about the substantive issues of the dispute, but rather assists the parties in making their own decision about the outcome. And there's a critical difference there.
And when you say the mediator assists the parties, do you refer to this as facilitative in nature?
Yes, very much so. And that's I think one of the principles of mediation is self-determination. And that means that the parties determine the outcome. And it's also a voluntary process where the parties have to be willing to come to the table to discuss the issue, as well as remain at the table to work through it. And the mediator's there to really encourage them to stay, help them identify common interests, and from there hopefully reach a resolution that meets both their interests.
That's a very important point, that it's voluntary. They haven't been summoned there, or frequently in my practice, I would probably be faced with a situation where a dispute is started and whether it's in suit or not. Can you tell us the types of disputes or uses that mediation would be found?
Sure, it's used in a wide area. I mean, it's anywhere from they have mediation in the schools where middle school children hopefully work through their playground disputes or whatever they are. They have it in high schools, colleges and universities have mediation programs. But in, say, the, I guess in our adult arena, they have everything from divorce mediation where, you know, husbands and wives can really work out some type of agreement or separation, or even with child custody that really works for them. Also, anything from property disputes, environmental disputes, really wherever there is a dispute, mediation is often appropriate. There are many cases where mediation is not appropriate. Oftentimes where there are violence involved, any type of, and mediation is not to be used in lieu of sentencing or some type of punishment.
In the criminal context,
Sure.
it wouldn't be helpful.
But oftentimes with criminal disputes, especially at the show cause stage, where the say two neighbors who are arguing would be, if it went to court and was processed, as you know, it could become a criminal matter. But oftentimes is that the two neighbors can sit down with a mediator, talk about what their argument is, and hopefully work out some type of agreement.
Have you ever had the experience? That's an interesting situation. Usually in a criminal type matter where it hasn't reached the criminal stage, it's gone before a court magistrate or someone has filed a complaint.
Mm-hmm.
And it hasn't quite reached the court stage. Have you ever been involved in a situation like that where the clerk magistrate has called the hearing and then you'd be involved in mediation at that point?
Yes.
And how would that actually work as far as the clerk magistrate and yourself as a mediator between the two parties?
Well, what would happen is that oftentimes the clerk magistrate would call our, say, organization, and they would say, hey, we have this case involving these two neighbors. The dispute involves maybe maybe the trash cans were put on the wrong side of the driveway. And they will say this, and it resulted in someone either verbally assaulting or maybe even it came to, you know, physical altercation. What would happen is that the clerk magistrate would refer the case. We would sit down with the parties and really identify what is, you know, prompting them to bring the case there, what type of resolution they might want to work out. And if the parties do reach an agreement, the agreement is given back to the clerk magistrate, who often checks in with the parties to find out if this is something they voluntarily came to, and if so, the case would be dismissed, and hopefully the parties would be able to live as neighbors again.
That would be very important in view of the fact that we're talking about a criminal context. The clerk magistrate, of course, has the power to say to the party that brought the complaint in the first place, if I find reasonable or probable cause, it's referred to the first session of the criminal court, and the matter goes on. So this,
right.
This would be a very important way of resolving a potentially very serious claim.
And that's, I think, what's key in that oftentimes if a case goes into the court system, the control of the outcome is taken away from the parties. And oftentimes if I mean, that's what the great thing about mediation is, that the parties determine the outcome. And anyone can try mediation. You just open the Yellow Pages these days and you find a number of mediators listed.
I want to backtrack just for a moment, Chuck. I did attend one of your training courses, of course, as you know, through Mediation Works, and I was actually quite impressed. I've been practicing law for 28 years now, and the mediation approach is quite interesting. I've incorporated that in our practice, and of course, it's, as you say, it's the magic of mediation. One of the things that you mentioned earlier on was that it is confidential, and I'd like you to explain to our listeners the confidentiality, which is very important as a part of this process and this particular statute.
Sure. Well, parties can be assured, I mean, if you have a ethical mediator, that everything that they discuss remains in the room. And so you maintain privacy. So oftentimes parties talk about things that they would rather not air in a public forum, such as a courtroom. So they can sit and with confidence be able to talk about things that often they're very personal, whether it's, you know, a divorce case or whatever. in Massachusetts, there is a law in the books that
Mass General Laws 233, Section
23C, yeah,
right?
that allows basically mediators who have taken a recognized training program and meet other criteria can also be protected not to be called in to, say, testify on behalf of either party should it later go to court. So that's just one bit of state recognition. Although unfortunately there is no, or fortunately or unfortunately, there's no state certification or recognition or national recognition, because it really is quite a young field. And
well, it's that is important if a person chooses to enter into mediation, that they realize that number one, it is voluntary, and number two, it's completely confidential. And at any point, the mediation can stop.
Right.
Because it'll move from either the facilitatory phase, which I'm going to ask you to get into shortly, and or the alternative is to go back to the courtroom or whatever the other alternative is.
yeah.
I'd like you to discuss with us, just briefly summarize how a mediation works from intake until the mediative process.
Sure. Well, if we take, say, maybe a case that comes into district court, maybe a small claims case, oftentimes when a party files a case in court, they do not expect to go to mediation. What they do is that they often expect that they'll go and have the clerk magistrate hear their case and make a decision for them. And what would happen is that the case is often referred, if it's appropriate, if, say, for example, you have two parties who have an interest in trying mediation, would go to the court. They would be referred to the mediator. The mediator would sit down with both parties and explain the mediation process, telling them that it's confidential, telling them that it's voluntary, telling them that the mediator doesn't make a decision, and telling them that they, the parties, will come out with the outcome. The mediation may take 45 minutes, an hour. It could take 4 hours. It could take a half an hour. And if they were able to work out a resolution that both parties find acceptable, at that point, the mediator would help them write up their agreement. They would then give the agreement back to the court, and then from there, the parties are, free to go. And oftentimes, the agreement would have the same weight as if the clerk magistrate entered a judgment.
I know that if any of our listeners have ever been to small claims court, probably you've had the experience of hearing someone say, this case can go to mediation. Take advantage of it. It really does help, because I don't think anybody really wants to let someone else make up a decision for them, such as the judge or the clerk magistrate, because the facts are heard, a decision is made, and that's it. The magic of mediation, as I understand it, is that the parties come up with the decision themselves.
Right.
It's facilitatory. Perhaps you could describe to us some of the process as far as what a mediator does when the parties present the facts to them, such as how you open up with the parties and what you try to accomplish as a mediator.
Right. So if you, for example, were a party who came in, and there would be you and the other party, say, sitting with me as a mediator, what I would say in my mediator's opening is one, just welcome to the process. Explain to them that this is mediation, and this is really an opportunity for the parties to talk about why they're here and to see if they would like to maybe work out some type of resolution they both find acceptable. But also at that time, explain that it's voluntary, is that if they don't want to remain in the mediation process, they can go to any other form, whether it's the court or whatever. Also, we would explain the confidentiality, that things will remain in this room, as well as the fact that if the party does not resolve, I cannot be called to testify on behalf of either of them. Also explain about the process that will start out in a public forum where both parties have the opportunity to talk about what brought them here. I would maybe ask to have a private session if necessary, where I would meet individually with each party.
So one party would leave the room,
right,
and you'd talk with that party.
Right. Okay. To get maybe there's things that they do not want to talk about in front of the other party. At that time, come back together, maybe in another, say, private or public session. If they reach an agreement, help them write it up, and it will be finished.
the means of mediation, the procedure. When a person comes in and they're really stuck with their issues, would you explain to us when a person comes in, they have a position, an interest, and how they differ?
Sure.
And how does a mediator move them from their position to the interests?
Mm-hmm. Sure. I think that oftentimes what propels people to, say, file a claim in court or to remain angry at a family member for years or whatever is oftentimes just a gut-level emotional reaction to something. And they're very powerful. And it's also what prevents people from reaching agreement. So it's a formidable task for the mediator to help them work through that and to really, and often those kind of strong feelings or saying, I want $5,000 for the work that wasn't completed, or I want you to apologize, are positional statements. People are taking a position, they're drawing a line in the sand. Whereas a mediator would really ask a simple question, is that, why do you feel that way? And oftentimes, the people who have those strong feelings haven't thought about it. They've really just been thinking about those positional statements. And oftentimes, the mediator's job is to help them kind of unearth those interests that lie below the positions.
So you let them vent as far as they're feeling. I mean, if I said, I'm really angry and I don't want to change my position, I want what I want, and that's it. What do you do with an attitude like that?
Well, I would say, first of all, most of the time I keep my mouth quiet or shut and let them talk, because, like you said, venting is really probably a big part of it. I mean, oftentimes parties who come in, I as a mediator, I'm usually maybe the first person who has listened to them for any length of time, and it really does. And I think if the person who they are in dispute with were to do the same thing, as maybe listen to them and really try to understand what they're going through, they may work things out on their own. But oftentimes people are, when they're angry at each other, they're not going to be so receptive or listen to the other. So I'm just thinking is that when they vent, I mean, oftentimes the things that I bring into the mediation room are usually a pad, a pen, calculator, and a box of Kleenex, because oftentimes during that venting it gets pretty emotional.
But there's a difference between a mediator and, of course, a person who's a counselor, a psychological counselor. You're not there to validate their feelings, and how does that differ? And as far as active listening, can you describe those skills along with reframing questions?
Sure.
And what those skills that a good mediator would do?
Yeah, I mean, it was interesting. I was just talking to a psychologist just the other day, and I really wanted to get her opinion or definition of, like, what is therapy, what is counseling, and then she was actually a trained mediator also, and to find out her view on that. And she described that therapy is very much a long-term process, a very facilitative, where the therapist would take the time to kind of understand what the party's going through and maybe help them reach some type of outcome. Whereas a counselor, maybe the counselor would give specific short-term specific recommendations about how to get through something. Whereas a mediator may do a little bit of each, but I know that at least when I mediate and many other mediators make it very clear that mediation is not therapy and it's not counseling. But it does use some of the skills, such as active listening skills, to help parties reach resolution.
Could you give us some
Sure.
examples of active listening?
Yeah, oftentimes is that things like acknowledging. I mean, really, when a party makes a statement, is to really acknowledge what they've said. Also, restating, oftentimes just to restate in other words or reflect back to them their emotional state. And also just to summarize what they've said. Oftentimes when a party in the beginning of a session has explained why they're here, we'll take a few minutes just to summarize what they said. And it's very powerful to really be an active listener and to really show somebody that you've listened to them.
So for instance, you might say to them, I believe you told me such and such, and repeat to them what they've said.
Yeah.
And also, I guess it helps them to participate more with what you're trying to accomplish.
Yes.
What other types of things, such as neutral language and focusing?
Yeah, neutrality is it's a very fine line. I mean, oftentimes sometimes if a party walks in and may remind me of my Aunt Bertha, who I don't really like.
Well, she's not listening, so don't worry.
No, I hope not. If not, sorry. But not she, but oftentimes that neutrality is something you really want to maintain, and it's very difficult to. I just spoke with a mediator who mediates with our organization this morning, and he was telling me that both parties approached him after the session in different locations of the court to try to get information, to try to find out what he thought of the other party, and he had to work very hard in just remaining neutral. It wasn't really a good idea to speak with any party outside of the session, but it was something that you're always being tugged as opposed to you're being either biased or you're neutral.
As far as the an experienced mediator's questioning skills, you need to move it from the effective listening stage. You've heard both parties. You've now reached a point where you believe you have some insight as to the real interests as opposed to their stated positions. How do you move the process to a resolution that the parties can realize themselves?
Yeah, I really think it's like what you just said is the idea of just once I can help them identify their real interests. Oftentimes those are interests that are compatible. Oftentimes both parties have spent a lot of money prolonging the dispute, taking it to court, hiring their attorneys, and things like that. And that's something that oftentimes I ask, what has it been like living with this dispute? And oftentimes, I can't sleep at night. I'm sorry that our friendship or relationship has broken because of this. And usually both parties say that. And oftentimes I can bring to light and tell the other party, what's interesting is that your concern matches exactly what the other person is concerned about. And just that realization that they have common interests is enough to base a potential agreement on.
Usually a mediation session starts with yourself or a mediator, or in some instances, I understand, a co-mediator, where there are two mediators that caucus together at different points. And they meet with the both parties, and the both parties together tell their individual set of facts or their story. And when you're through talking to them, then I understand you will have a private session with one party and the other. And each party will tell you whether or not that information should be held confidential or can be disclosed to the other party. Is that pretty much how it works as far as the session?
Yes.
And then you get them back in together, and now you have an opportunity to discuss with them both in the same setting what you now realize may be their interests and, as you say, their common goals. Are there some instances? Obviously there are instances where the whole process gets stuck.
Absolutely.
And what do you do when it gets stuck?
Yeah, there's
instances when it gets
there's definitely difficult situations. There's a number of things that a mediator can do to help kind of get unstuck. Oftentimes is just to ask a bottom line, what are we doing here kind of thing. Oftentimes, like I've worked with parties for hours and hours, and no one's coming up with any ideas to reach a resolution. And sometimes you just have to get to the very bottom line, just saying, look, if no one's going to make any movement, this is not really worth any of our time. Or
our time is over and we need to move on.
And oftentimes that parties have shouted out potential options when I'm getting out of my chair because they know that perhaps I'm serious. So there's other strategies. And also just to really, I think also just the opposite of that is really to show the support, or actually to show them how far they've come by actually stating, you have agreement on this, this, and this. Why not tackle this last thing and try to work out something that works for them?
There are certain questions that a mediator avoids. Can you give us some instances of that? I know that with our workbook here, there are a lot of instances, but maybe you could just share some of those with us.
Yeah, I think that in general, asking open-ended questions as opposed to closed-ended questions.
Could you give us an example of that?
Yeah, if I asked you, say, Marvin, what do you prefer, chocolate or vanilla ice cream?
That gives me a choice of chocolate or vanilla.
Just two. Right. But if I said, out of the whole, say, Ben and Jerry's spectrum, what would you choose?
So that it's much more available as far as choices.
Right, so it's something that, it's, when you ask an open-ended question, you'll find that you'll get many different answers. But if you ask a closed-ended, you'll get either a yes or no, and it's very limiting. And I think that the mediator's job is to really uncover or to, like I said, unearth more information than less.
On another show that we're going to be doing following this program, we're going to actually have a mediation session, and you're going to participate in that, and it's a program I hope our viewers will watch at a later time. Just wanted to review some of the things now as far as active listening or the mediator's focusing ability. Are there things that you'd like to share with us on that?
No, I think if anything, I would encourage people, if they are in a dispute of any type, to try mediation. I mean, one of the reasons we named, the organization Mediation Works Incorporated is literally believe in that. Yeah. And it's something that often, encourage people also, if they don't know what it is to, like I said, open the yellow pages, call maybe a mediator. There are community mediation centers around. There are state associations. It's an exciting field, and people who may be interested in learning more about it can find out through those avenues.
Yeah, I'd also encourage anyone that's in a dispute represented by an attorney at this time to ask the attorney whether or not their matter might be appropriate for mediation to resolve the dispute, in which rather than giving it to a jury, and the only certainty we say as far as a jury is considered is the uncertainty of the decision by a jury. There are a lot of training sites and organizations that train mediators. If our listeners feel that they want to become mediators, maybe you could tell us just briefly a little bit about that.
Sure. I would recommend, there's a state association called the Massachusetts Association of Mediation Programs and Practitioners in Boston. And their number, if I don't know if it's appropriate, but
sure.
It's a state association, is 617-451-2093. And they have a listing of all different training programs throughout the state. And there may be one, in the Burlington area or anywhere.
All right, fine. Well, we're about running out of time for this particular program. I want to thank you for being with us, and I want to remind our listeners that we are going to be having another program with you and an actual mediation example of what happens during a real mediation, or at least a focused mediation in our studio. And we're also asking our listeners to write to us. You'll have our address. It'll appear for just a brief time right at the end of the show. And we want you to write to us for future programs that you'd like to suggest to us. And we'll certainly try to provide someone to speak, like Chuck has come today. And if you want to contact us for a mediation program, as Chuck has discussed, we could try to provide you with that information. In the meantime, we want to thank you for joining us on Speaking of the Law, and we look forward to being with you on the next program. Thank you for joining us in this program. Thank you.